Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to our Curious Amalgam. I'm Alicia Downey, and the title of today's episode is, How Does U.S. Law Promote Competition in Agricultural Markets? President Biden's executive order of July 2021 identified agriculture as a sector of particular antitrust concern, citing increased consolidation and the perceived resulting harm to farmers and ultimately consumers. Both FTC and Department of Justice leadership have been speaking regularly about the need to protect farmers from anti-competitive practices by the large enterprises that not only purchase the farmers' output, but that sell critical inputs such as feed and farm equipment. In the fall of 2023, the Department of Justice and 6 state attorneys general sued a third-party data-gathering, benchmarking, and consulting company called Agri Stats, alleging that it facilitated an anti-competitive information exchange among broiler chicken, pork, and turkey processors who paid for access to Agri Stats data. We'll hear more details about this case from today's guest, a law professor with expertise in agricultural law and policy. We'll also hear about DOJ's revival of the Packers and Stockyards Act of 1921, an industry-specific law that includes its own prohibitions against unfair, deceptive, and anti-competitive conduct toward farmers of livestock and poultry. Government enforcers are looking at the potential to revive this statute to support challenges to conduct that the Sherman Act might not reach. My co-host today is Barry Nigro. Hello, Barry.
Hello, Alicia. How are you?
I'm fine. Barry, would you like to introduce today's guest?
Absolutely. We are joined today by Professor Kelly Nuckolls. Kelly is the Assistant Director and Visiting Assistant Professor of Law for the University of Arkansas School of Law LL.M program in Agricultural and Food Law. Kelly previously worked as a Senior Policy Specialist at the National Sustainable Agriculture Coalition, where she advocated for federal policies related to sustainable agriculture, including the Farm Bill, food safety, and food labeling laws. Kelly has also taught food law and policy at George Mason University Law School and serves as a board member for the Women, Food, and Agriculture Network. Kelly, welcome.
Thank you. Thanks for having me.
So let's start in the supermarket. And, I go in, occasionally I'll buy a package of steak. I have no idea how it gets there or what the supply chain looks like. Can you give us an overview of the players and their roles in agricultural markets?
Yeah, of course. And I might give an overview of what a steak might look like and then kind of briefly talk about poultry as well, since that's the product that's in discussion in this case. But the supply chain for beef, as I mentioned, is a little different, a little more complex than poultry. It starts with a breeding facility, which is a separate business, and then the calf is born on what's called a cow-calf operation, and it's raised until a certain age, and then it's sold to a different farm operation called a backgrounder, where it's grazed until a certain weight, and then it is sold to a feedlot, and the feedlot is the last stage before it's sold to the meat processor, and that's where it's processed and slaughtered and then sold to a wholesaler or a retailer to eventually end up on the grocery store shelves. What's kind of interesting about beef is when the feedlot sells it to the processor, it's either via an alternative marketing arrangement or it's via a cash or spot market transaction, which is usually a competitive bidding versus an alternative marketing arrangement, which is more of a contractual relationship for the cattle at a set price. The poultry industry, as I mentioned, is a little different because it's more vertically integrated through the production process. So one company will own the hatcheries where the birds are born, and then will place them at a farm. They'll still own the birds during that process, And the farmer is essentially providing kind of a fee for service. They're providing the housing, the labor, the water, the electricity. And once the bird is at a certain weight, the processor will come back and transport that bird to be slaughtered and then further processed, maybe into something like chicken nuggets. And then it will again go through that process of being sold to a wholesaler and eventually end up on retail grocery store shelves.
I had no idea there were so many intermediaries in the supply chain. There's been a lot more attention given to whether agricultural markets are competitive. And there are lots of things on which we can focus. But let's start with the antitrust case that the Department of Justice recently filed against Agri Stats. As I understand it, the case alleges that Agri Stats violated Section 1 of the Sherman Act by organizing and managing anti-competitive information exchanges among broiler chicken, pork, and turkey processors. And that information exchange allegedly, according to the DOJ, allowed the processors to coordinate pricing and reduce supply, ultimately leading to consumers paying more than they otherwise would. Can you provide a brief overview of the DOJ lawsuit and talk about some of the allegations and causes of actions and the relief that's being requested?
I might start with just a little overview of what Agri Stats does. They are a subscription service focused on meat, poultry, and commercial egg industries. And companies will go and submit their internal data to Agri Stats, who will then organize it weekly and monthly into reports and graphs. So companies can kind of compare how they're doing to the market. And this will include things like prices on certain products, worker wages and benefits, pay to farmers, and even how much product they're producing. And sometimes Agri Stats can even provide one-to-one consulting services related to the data for a company. This data is kept confidential. It's not shared outside this industry. It's not shared with buyers or workers or farmers. So I might just give a quick example. A report might compare the company's sale price on a specific type of product. Let's say you're going into the grocery store to buy 85% lean ground turkey, and they'll show the company what their price is when they're selling at wholesale versus the Agri Stats price for that product, which is kind of a summary of what all of the competitors' prices are. So that's just one example of one of the reports that a company might receive. And so in the US v. Agri Stats case, the Department of Justice is essentially alleging, and I'm kind of paraphrasing here, but they're alleging that the exchange of this information has led to companies taking certain actions to increase their profits based on these recommendations from Agri Stats, whether that increase is to increase the sales price of a product or lower even costs such as worker wages. But I think the main thing they're alleging is that companies have lowered their supply based on these reports and were allegedly encouraged by Agri Stats to do so, which then reduces input costs, increases demand, and their prices are then driven up. So company profit margins are driven up. They're also alleging that the anonymization of this data is, and I quote, superficial, and that it's clear that because they provide participating company names and even facility level specifics, that it's really easy for companies to de-anonymize the information. And so with this, DOJ is claiming that all of this evidence shows actions were taken by Agri Stats, that with their co-conspirator companies, they've agreed to share this competitively sensitive information, which helps coordinate price and reduce supply, and again, results in higher prices for consumers, unreasonably restraining trade, and suppressing competition in violation of Section 1 of the Sherman Act. And so with that, DOJ is hoping the court will rule that this information exchange is in violation of the Sherman Act. And they're also asking the court to permanently enjoin Agri Stats from sharing this information in the future.
The Minnesota federal court overseeing the litigation denied Agri Stats' motion to dismiss, so it looks like that case is going forward for a while. Was there anything notable about the decision to deny the motion to dismiss and the accompanying motion to transfer venue as well, to bring the case to Illinois, where there's other pending litigation related to the use of agri-stats in the broiler chicken industry. Is that right?
Yes, that's correct. And I think how the judge points to that case, which is in re broiler chicken antitrust litigation, the one you just mentioned, I think the judge is saying clearly in the in re broiler case, the judge dismissed the claims against agri-stats. And so here, the DOJ is going to need to provide additional evidence and able to succeed on their claims. But I think the judge is already kind of hinting at, especially in the motion to transfer decision, that there's already more evidence provided in this case versus that case. The judge actually cites to a few examples, including a list of all participant plant names by their location and city and state, and saying by providing this level of facility information, it's really easy for companies to de-anonymize the information. He also points to some statements from Agri-Stats employees where they were suggesting that a certain price of one company was higher than the other main supplier of a product, but well under another supplier with less volume. And when there are very few companies offering this product, it might be really easy to determine who they are. And so I think that depending on what evidence DOJ continues to uncover, what comes out of discovery, it really will depend on whether or not DOJ is able to succeed or whether the same outcome will happen as the in re broiler case.
The other thing I noticed in just glancing at the briefs is that Agri-Stats brief in support of the motion to dismiss pointed to an earlier DOJ investigation that I believe it was in 2010 that resulted in no action. What can you tell us about that investigation?
We don't know much, Alicia, but we do know that it was a 2-year investigation, and it resulted in DOJ closing the investigation with no suggestions or requests of Agri-Stats. So I think it's interesting. This is the same time period that they're alleging in the current case against Agri-Stats. And so I think some are wondering if other cases have uncovered additional evidence which led to the DOJ interest in bringing this claim during that exact same time period. Some cases that they point to include the recent DOJ case against Cargill, for example, where Agri-Stats was part of the problem that Cargill was participating in Agri-Stats.
Yeah, and this information sharing has been a critical focus of the Department of Justice. They recently withdrew some of the guidelines with respect to information sharing, so it's not surprising that they've been more active on the enforcement front. Kelly, it's obviously too early to predict what the outcome's going to be in the Agri-Stats case, but if we assume that DOJ ultimately is going to prevail, what are the potential implications for processors, farmers, and consumers?
Yeah, I think the DOJ complaint is very thorough and comprehensive in targeting a majority of Agri-Stats reporting for these industries. And so I think it's likely if they were to succeed, Agri-Stats probably wouldn't have a lot of business left. Now, who knows if that will happen? I don't know what the court will decide. As you mentioned, we can't assume that it will even reach a final decision. Maybe a settlement will occur. So maybe that will look a little different too. Maybe it will look like Agri-Stats having to significantly change their business model to comply with whatever relief is requested. And if that occurs, they're really going to have to make sure that their business model is enticing enough for companies still to participate. There are public data options available to companies related to some of this information. It's not as detailed and it's maybe not as current, but there are some other options available that processors might be able to use. So I think it will be interesting to kind of see what happens and if Agri-Stats has to change their business model and maybe even do a better job of anonymizing the data. I think for processors specifically, I think that, again, maybe they'll shift their business models and rely more on some of that public-facing data from the Department of Agriculture, for example. I also have heard, and I've even talked to a few companies that are looking to hire attorneys in this area of compliance. So for all you law students out there, that might be a really good job opportunity in the future if you're interested in agricultural law. And then when we think about impacts on things like workers and farmers, I have read that experts are kind of skeptical that it will really increase wages for those two sectors significantly, just because we haven't really seen significant wage increases regardless of this data across other industries. But I do think that, at least for farmers and even for workers potentially, just some of the new policy making that's coming out, specifically for farmers, some of the DOJ cases in other areas and the U.S. Department of Agriculture's Packers and Stockyards Act policy shifts will probably increase farmer wages more so than maybe this case would. Finally, I think consumers might see the most significant impact of this case, depending on the outcome. I've read some headlines that have stated this is the cause of overpriced meat for the last 40 years. Whether that's true or not, if the allegations are true, it's probably a pretty significant reason why meat and poultry prices have been higher in the marketplace. Probably not the only reason, but at least consumers might be able to see those price increases maybe stabilize a little bit. And so I think consumers overall might see more significant of an impact than others in the industry.
You mentioned the job opportunities, and I can say that since the DOJ announced that it was going to focus on information sharing, and in particular after it brought this case, I've had more calls from clients either asking whether they should continue to participate in these sort of third-party information sharing services or whether they should withdraw. And it's interesting because I do think that companies are paying attention, and in a lot of cases, surprisingly, or maybe not surprisingly, they said they really didn't find this information very useful, so they decided not to continue to participate. So it's kind of interesting, and it'll be interesting to see sort of what impact the outcome of this case has in the agricultural sector as well.
Yeah, I agree. I mean, companies are paying a lot of money for this data, and if it turns out to be not useful, then I assume they'll stop participating.
Now, you mentioned the Packers and Stockyards Act of 1921. At the beginning, we promised we'd shift focus and look at that statute. We have many, many, many episodes all about the Sherman Act and the application of antitrust laws to all sorts of things. I don't think we've ever discussed the Packers and Stockyards Act of 1921 before. So, for the benefit of listeners who do not come from cow country, just in general terms, can you tell us a little bit about this statute, who it's intended to protect, and against what kind of conduct?
Yeah, and I'm excited that we're talking about it. We might have to talk about it in more detail another time, but the Packers and Stockyards Act was enacted in response to meatpacking industry concentration at the time. The big five meat packers back in 1921 were controlling the market and even controlling prices and dampening competition. And so Congress thought, well, let's create a statute that goes beyond kind of the antitrust laws specific to this industry that will protect farmers and ranchers and consumers and even members of the livestock and poultry industries from unfair competitive actions and trade practices. And so there are kind of two different parts, and I think we'll probably focus on the one that's more related to anti-competitive conduct. But there's also some regulatory components, which I won't mention today. The anti-competitive prohibited trade practices sections really stem from sections 202 of the Packers and Stockyards Act, and the most contentious parts include sections 202A and 202B, which state it's unlawful to engage in or use any unfair, unjustly discriminatory, or deceptive practice, or make or give any undue or unreasonable preference or advantage. And so, yeah, that's kind of the big theme of the Packers and Stockyards Act, is really looking at where are situations that might harm consumers and farmers and others in the industry.
Well, some of that language seems a little bit familiar from the FTC Act, which, of course, is what authorizes the Federal Trade Commission to bring enforcement actions against not just technical violations of the Sherman Act, but also other unfair methods of competition, unfair and deceptive trade practices. Historically, what's been the role of the Packers and Stockyards Act in government enforcement? Are there any notable cases that sort of assess what the standard is for identifying unfair competition or anti-competitive practices in that context?
I kind of hinted at this already, but there's a lot of debate around whether or not the focus of the Packers and Stockyards Act should require proof of anti-competitive conduct to bring a claim under sections 202A and 202B. And again, we're looking at things like unfairness, deception, unjust discrimination, undue preferences, which are not always in other antitrust laws, in that language specifically. And so there are a number of Court of Appeals decisions that have said you do need to prove this anti-competitive conduct for these actions to succeed. And I would say if you're really interested in learning more, Wheeler v. Pilgrim's Pride is a Fifth Circuit case, which includes kind of a very lively debate around this and provides a really good overview of what the courts have said in this area.
Excellent. So Kelly, there's been a lot of talk by this administration about reviving the Packers and Stockyards Act. Are there any indications that the Biden administration is going to bring more cases under the act?
I think that there's a lot of signs that they're really interested in potentially bringing cases under the Packers and Stockyards Act. The first one that I might mention is that in 2022, the Department of Agriculture and DOJ partnered together to create a website. It's www.farmerfairness.gov, and they're actually asking for farmers and others to issue complaints at that website around violations of the Packers and Stockyards Act. So I think they're probably looking based on that alone. But there are some other actions as well, including even some recent DOJ actions in US v. Coke Foods and US v. Cargo, which I already mentioned. And then the rulemaking coming out of the Department of Agriculture. So there are already 2 new final rules within the last several months that have come out, including one on inclusive competition and market integrity and transparency in poultry grower contracting. And then actually earlier this week, they just released a proposed rule on poultry grower payment systems and capital improvement systems. So USDA has been busy in this area. And even in that new proposed rule, they said they will be ready to work with the DOJ to enforce this rule.
So there's an awful lot going on in there. This has been a very interesting conversation, and I think we only just scratched the surface of everything that encompasses agriculture and antitrust. But we don't have totally unlimited time. So just switching gears for a minute, we want to find out a little bit more about you as a person and your practice. One thing I'm curious about, though, Barry mentioned in the biography that there's an LL.M program that you head up that specifically looks at agriculture and food law. Can you tell us a little bit about that program? And I know you are in Arkansas, so you really are in the heart of the part of the country where a lot of these businesses operate.
Yes, yeah. And we have a program that's been around for over 40 years now. We offer a really robust curriculum in food and agricultural law, anything from food safety to antitrust in agriculture. And we offer both full-time in-person or online or part-time online opportunities for our students. So we have students from honestly all over the world that participate. We like to joke that our classroom looks a little bit like a sports bar because we have big screen TVs all around the classroom. And so it's like our distance students are here in the room with us. And so it's a really great program. Last year was the first year we actually offered the antitrust law class. And so we're really excited to offer it again. And we think it's probably the first one in the country that really focuses on these topics as they relate to agriculture and food law.
Since you are in the law school context and you deal with both law students who have not even gotten their JD and post-JD students, aside from getting into the compliance business, What other advice do you have for those students?
I would say during your time in law school, look at internships in the areas you're interested in. It will not only set you up for success when you go out and start your career, but it will allow you to apply for a job with that relevant experience in hand. And I think that will really make you a competitive candidate in the job market.
Kelly, that's great advice. I couldn't agree with you more. Now let's focus a little bit more on you. And could you tell us something about yourself that we would not know if we knew you only in a professional setting?
Yeah, I don't think any of my colleagues know this about me. I'm a pretty avid water skier. I like to spend my time in the summer on the lake. Here it's really beautiful because we have like the Ozark Mountains, which are rolling hills. And when you're on the lake, it's just really relaxing to be behind the boat and looking out at those hills.
I don't think of water skiing as relaxing. I think of it as white knuckle, terrifying experience, but I'm glad you like it.
Yeah, I promise it's not as terrifying as it may seem.
Oh, all right. Well, before we let you go, though, we're going to have you play a little game we have many of our guests play. It's called The Curious Hat.
And now it's time for The Curious Hat!
The rules of the game are extremely simple. We're going to have Barry pull a random surprise question out of a virtual hat, and you will do your best to answer it. Go ahead, Barry.
Okay, Kelly, reaching into my virtual cowgirl hat, and it may not be a coincidence that the question is there any popular food that you dislike intensely?
Popular. I think mushrooms are pretty popular. And I do not like the texture of mushrooms. So I avoid mushrooms at all costs. I have a lot of friends that like to go mushroom hunting, and I tell them, please don't bring me any of the mushrooms you find.
Interesting.
Okay. Yep. All right. So next time we order pizza, no mushrooms for you.
Yes.
Well, thank you so much, Kelly, and thank you, Barry. It was a great conversation. Thank you to our listeners. Tune in for next week's Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.